Dry? Trying to stay dry? David, can you hear me back there? Can you hear me talking like this? Can you hear me back there, Kevin? Okay. Very good. Well, it's been 2 weeks since I was here. After that evening, I ended up getting laryngitis, and for about a week, a little more, I literally could not talk. So I had to stay home from work and church and everything else because nothing would come out of my mouth. So, but feel back to normal now and good. So, just in time. I trust things went well last week and you edified everybody. I think last time we spent our time going over the definitions of a bunch of terms, and I thought, and if you remember, I had prepared 2 segments for that class. It was going over the definitions and then talking about the differences between wills and trusts, and we didn't even hardly get through with the definitional terms. So we're going to start tonight with wills and trusts. And I don't specifically have anything planned tonight in terms of any scriptures, if you will, but I think as we have our discussion, we can think along the lines of how this is tying into spiritual matters and planning and things like that. And kind of the overarching thought process for my portion is, even though mine's 95% on the legal side of things and not devotional thoughts and spiritual matters per se, is that just part of being a good steward and part of planning, being a responsible person. And of course, I think if we're trying to be true to our Christian principles, we would want to do things that would make God pleased. And I think one of those is planning, because if we don't plan, then we're all going to pass away, and our asset, something's going to happen to them. And I think to the extent that we can direct them and thoughtfully do so in view of God's kingdom, that's why the elders thought it is important, even though knowing that most of my discussion would be more on the legal side of things. But we're going to talk a little bit tonight about wills and trusts. And then next time I have the floor, I think we're going to then talk about powers of attorney, financial powers of attorney, medical powers of attorney, and advanced care directives. And Gary, did you have an advanced care directive night that it was planned a week from tonight? Okay, so it sounds like it might be good then if we use the next week on the legal side, maybe amplifying what you've opened the door to as far as advanced care directives. Yeah, Bill.
Is there a certain number of things that we should have in place as we get older, as we consider our giving, and that giving can continue after we're not here? For instance, I think everything that you mentioned, will, trust, directive, etc.
Mm-hmm.
Is there 5 or 6 things that everybody ought to have?
That's a good question. I think so.
And what are they?
So every time I do planning for somebody, it just, when somebody says, I need to come get my will updated or whatever, it's always going to include either a will or a trust. Now, we're going to talk about trusts and how, even though you have a trust, you probably will have a will. Typically, we're thinking in terms of, is our major planning vehicle going to be a last will and testament or a trust? So that document would be one. And then you have the power of attorney. If you're going to be choosing the same person to be your, we use the term, he's my power of attorney, she's my power of attorney. That's technically not correct. That document is the power of attorney. That person is your attorney in fact, or your agent. So if I have a power of attorney document where my attorney in fact is my wife, And my secondary option is my brother, let's say hypothetically, and that's my financial. In my medical, Trina is my attorney, in fact, and my brother is my alternate. Then I would combine them into one document, a combined medical and financial power of attorney. So that would be document number 2. If, and it's very often that the first person on both will be the same, but the alternate for medical is going to be different than the alternate for financial. And then we would have a separate financial power of attorney and a separate medical power of attorney. So in that instance, you're up to 3 documents. So 2 or 3, depending on that route. And then we always do the advanced care directive, which we all used to call a living will. And people get confused a lot on that, and we're going to talk about that a little bit. A living will is that document that is used while you're alive to state your wishes about medical care and intervention when you can't speak for yourself. And there is overlap with that in the medical power of attorney as well. And so next week we'll get more in detail on that and how those dovetail together. But what we used to call the living will, and it basically, if you had any planning done over like maybe 10 years ago, you did a living will. And the living will, there's two choices. I want to be hooked up and kept alive even though there's no reasonable medical expectation of my recovery, yes or no? And do I want to be an organ donor, yes or no? That was the form. Now, Tennessee has a statute and has a prescribed form that most practitioners use. That's an advanced care document where you go into greater detail about what quality of life means to you and what is an acceptable quality of life. There's about 5 scenarios that you check yes or no, is that acceptable? And then the various treatment options below that you can choose yes or no. The idea being, if category number 1 is I'm in a permanent state of confusion, is that an acceptable quality of life to me? Most people would say no. Now, some people may say I live in a perpetual state of confusion, but and I feel like that sometimes. But let's say hypothetically the answer to that is no. That is not something I want to live with. Well, it's very confusing because folks are like, well, no, that's not acceptable to me, but you know, I don't want somebody to kill me. I mean, if I don't, whatever. The point is, these things, are those an acceptable quality of life? Typically, we'll say no. And like one of them is, you rely on others for all of your daily needs. Another one is, you don't recognize loved ones and you have no idea who people are, that kind of thing. And then below that, do you want CPR? Well, the idea is, if I'm in permanent state of confusion and I've said that's not acceptable to me and I need CPR, do I want CPR to be brought back to a state of permanent confusion that I said I don't want to be? That's how those two work together. But I had somebody in my office today, and we did the will and powers of attorney, and we got the advanced care directive, and this happens every now and then. He absolutely could not do it. He could not find his way to figure out yes or no on those. And when that's the case, then there's no point in trying to coach people through it, because he doesn't know what he wants or how he feels about that. But most people are pretty quick to say, no, I don't want any of these things. Now, you may live to be 110 with Alzheimer's and never need CPR or advanced care treatment for a terminal illness or whatever. And so those bottom sections, those treatments never come into play, even though you have Alzheimer's and you said this is not acceptable, because you naturally are going to live until the Lord takes you home, right? The question is, if I have any of these and I need heroic measures, do I want the heroic measures or not to bring me back to a state that I said I don't want to be in? You know, in the classic case was the Terry Schiavo case from, I guess that was probably even in the 80s or 90s, where she lived forever with the tube feeding, and some of the family wanted that and some of the family didn't, and that's kind of the classic case that everybody remembers. So that form is super important, and I like it way better than the old living will. Because old living will used to be, do I want to be kept alive or not? Do I want to be an organ donor or not? Well, my goodness. Even where it says, where there's no reasonable medical expectation of recovery. Well, what does that mean? I remember when my father had his first round multiple myeloma, and he was really sick in intensive care in St. Thomas, and he lived 10 years past this event. I remember the internist telling us something to the effect of, because he was kind of critical, something had happened, he's kind of critical, something to the effect of, well, he's not going to survive cancer anyway. And it was kind of like, there's no reason to go overboard. He's not going to make it anyway. And she literally kind of had that attitude towards me. And one of the physicians, the cancer doctor, I don't know if he was standing there, he stepped in and said, "You're crazy." He said he could have 10 years of a good quality of life if we can get past this hurdle. And he did. He made it through, and he lived 10 more years before another complication of multiple myeloma took his life. And I had a really neat opportunity. That doctor, who at the time I guess that was 20 years ago. He's been deceased 10, and that was probably 10 years. So I was on the early part of my law career, and I had a chance. That physician called and asked me to represent him on a real estate matter that was kind of my expertise. And so I had a chance to represent him, and I sat in his living room and reminded him of that event. And, his intervention really was the reason my father possibly had 10 more years of life and that we had with him because of that. And it was really a neat kind of circular kind of thing where I was able to help him and thank him for what he did for us. But that's an example of the old living will, one doctor's perception of, no, if he goes into a coma here, there's no expectation to recover, so don't put him on a ventilator. Whereas the other doctors, it was, well, sure, we'll put him on a ventilator, because if we get him past this one episode, then what he's on the ventilator for has nothing to do with his cancer, and he could have 10 more years of life. So the new advanced care directive is much better, and I'll bring that form so you guys can see it and see what I'm talking about. And most people really like that, and I think it's a real service that has been done to the residents of Tennessee to have that form to use. And in that form, you also specify who you want making decisions for you, and of course, we make sure that gels with the medical power of attorney. Anyway, so it's the will or trust, powers of attorney, and advanced care directive. That's under my purview. Now, there may be other documents that you want to have with your financial advisor, your stockbroker, your retirement plan coordinator, et cetera, but that kind of goes back to our discussion a few weeks ago about joint accounts, PODs, and things of that nature. So that's typically the suite of documents we're talking about. Would you concur that that's typically, and that's any practitioner, that's what they're going to say. Which leads us into wills versus, yeah.
For those of us who have not been in this class that y'all have you talked about in the absence of will or trust, what happens to your assets?
We did. So real quickly, whether you have a written will or not, you do have a will. And the state of Tennessee has a plan for your assets if you die without a written will. That's called dying intestate. And there's basically a family tree that the statute says if you die and you have a wife and children, this is what happens. If you die and you have no wife and no children, this is what happens, and so on. And so there's a decision tree, and it typically follows exactly like you would want it to. So I think I have no issue with that. And sometimes people come to me, and it's so clear that if they die without a will, the end result is going to be exactly the same thing. I'm not necessarily going to make them or guilt them into not doing a will with me and spending money if the end result is going to be exactly the same. So we kind of take things as they come and make those decisions. But if you don't have a will or a planning document, then your asset's either going to pass to a joint owner of the asset, whether it's real estate or a bank account, a payable on death, a beneficiary designation, or something to that example. And we spent a whole week going over that there. So, but generally speaking, having a written plan for your assets upon your death is going to be much more advantageous and more favorable for you. So a will is, I made notes to help me kind of compare things. A will is a tool that directs whom you'd like to leave your assets upon your death. It names a personal representative. We know those people, that term is executor or executrix, who will do the administrative work, getting the assets where they're supposed to go per your instructions in the will, winding up the deceased person's affairs, etc. And if you have a will, then, and it is, if it needs to be and should be probated, which is generally speaking the case, then it's got to go through the probate process. So that's the first thing that makes it different than a trust. And typically an attorney is needed if you're going through the probate process. There's some jurisdictions that require a person to hire an attorney to navigate that process. And not all do, but most do, unless it's a small, very small state. As opposed to a trust, and most people think in terms of a living trust or a revocable trust. And don't let the word living confuse you. What we were talking about before was a living will. That has nothing to do with a will. A living trust is a document that is an alternative document to a will. It does direct whom your assets go through at your death, so in that instance they're similar. But it also governs your assets while you're alive, hence a living trust, as opposed to a will. A will only speaks upon your death. A trust speaks the minute you sign it, and you breathe life into it and you fund it, meaning you actually title something. There's lots of people that have trust documents, and they pay a lot of money for trusts, and they show me their trust and whatever, and they don't have one asset titled in the name of their trust. That trust absolutely has zero value unless it's funded. If your point is to avoid probate, which is what most people's reasoning for having a trust is. So a trust can be helpful during life because it's effective during your life, not just at death. A will is just at death. A trust names a trustee. Typically the trustee is the person that owns the assets that comes to me, and we set the trust up for a couple, the Montgomery Family Living Trust, and me and Trina are the co-trustees, or the Bill Pinnell Trust, and Bill would be the trustee of the trust. That's 9 times out of 10, that's the case. And then you name a successor trustee, and this is where it gets, I think, interesting. So in a will, I might name my wife as my executor, but if she predeceases me, then I name my brother as the alternate executor. Let's say in the trust route, I name, Trina and I are the co-trustees. One of us passes away, the other remains the sole trustee, but upon our last death, then we have a successor trustee named. Well, that trust, just because she passed away, I passed away, that trust doesn't end. That trust is a living, breathing entity that survives. And the fact that I'm passed away and she's passed away, we now have a new trustee that automatically takes control of the trust, and there's no need for a probate or a court to intervene because the exact same trust was here today is here tomorrow. And the same assets that were in there yesterday are in there today. The only difference is we have a new person that's now running the show. That's why it avoids probate. Because probate only, that's the difference between a will. A will only speaks upon a person's death and when it's admitted to court through the probate process. So that's a huge difference. And most, we'll talk about this in a second. The successor plays an equivalent role to the executor. That's what I was getting at there. But the difference is when you have a will, the administration of your estate and your assets that's happening through the probate process where the will is being carried out by the executor, that's through a public process. It's in the court system. And if you have any compelling reason to see what's going on, the court will typically allow you to see what's happening in an estate. It's public record. So if you have a trust, that never happens because there's never a court system that gets involved to administer your assets because it's being held privately. It's a private administration of your assets as opposed to a public administration. And an attorney may or may not be involved in the trust route. Typically they are, because in Tennessee, we still have a few things that we have to go through administratively to make sure that assets that pass from a person that dies with the trust gets to the next generation. We have to clear a couple things with a couple government agencies so it's free and clear to your beneficiaries. But the next difference, probate is required with a will. It avoids probate with the trust. And to be honest with you, that's why most people come to me and want a trust instead of a will, is because they want to avoid probate. So, David Elliott sent me a message a week or two ago, and we kind of bantered back and forth a little bit because he said, "It sounds like to me trust really are the way to go, you know." And you seem to have a bias against trusts, but they really sound like they're better than a will. And you know, on the surface, that would seem to be true. And who knows, I may change my mind. I think at this point, I'm kind of depends on the facts of the situation. But if avoiding probate is your main goal, why is it your main goal? Is it because you think that the public is going to want to see your assets, and so that's why you're avoiding probate? Because if that's the case, I promise nobody cares. Unless you're Tom T. Hall or somebody like that. Then they care. And most of the time, the court systems are pretty good about when you have a request, I want to see that. Well, what's your compelling interest? Why do you want to see that? And then most of the time, they don't get to see it anyway. So is it avoiding public scrutiny? That possibly could be a benefit to avoid probate. Is it because you want your beneficiaries to have access to the assets quicker? That's a legitimate reason, potentially. But I think we talked about a few weeks ago, we can set accounts up to where if you're worried about your children or your heirs having money to kind of live on or enjoy a little bit of their inheritance before the probate process is finished, we can skin that cat with some accounts and things like that. But sometimes that's the reason. I want my family to enjoy the assets quicker and not have to wait through probate. Another reason is I don't want to involve attorneys, and attorneys just charge a lot of money, and so I would rather do a trust because no attorneys and court and all that's involved. Typically speaking, the cost to do a will and that suite of documents is much cheaper than the cost to set up a trust and to go through the process of funding the trust. When you pass away, you may not need much of the attorney's help on the backside but you paid way more money on the front end to get it set up, and at the end of the day, it's about the same difference in terms of costs, actually. But anyway, the avoiding probate is usually why people want to do a trust. The other reason people will want to do a trust, and I do think this is a good reason sometimes, is if you have real estate that you own outside of the state of Tennessee, then we're going to talk about a trust and have that real estate being owned by a trust, as opposed to you owning a beach house in the Gulf and a place out west that you visit, you know, condo in Aspen or something like that. Because if you die with a will, your estate's got to be probated in Florida. In Tennessee, that's the domicile probate, and then you've got an ancillary probate in Florida and an ancillary probate in Colorado. And that can get very pricey. So when clients come to me and they have multiple investment properties, then there's a factor then that we start looking at, well, do we want to do a trust route instead of? Or do we want to do a will for 90% of your assets and a trust for your investment properties, so you don't have to be dealing with an attorney in Florida that you don't know, and the court system that you don't know, and how much are they going to charge me, and how long is it going to take, and all that. Generally speaking, in Middle Tennessee, probate doesn't take that long, it's not that expensive, and it's not that big of a deal. Back in the old days, this is before I practiced law, my understanding was in some of these rural counties, probate lawyers would charge 10% of the assets that went through probate, and the judges allowed that. So if you had $1 million estate, the attorney got $100,000 to probate the estate. You know, that's unconscionable, obviously, and so I don't know of any jurisdictions that allow that anymore. In Middle Tennessee, the judges are going to want, if there's any attorneys getting paid from the estate, you have to submit your time sheets and file motions and get your fees approved and all that kind of stuff. Avoiding probate. Probate's required in a will. It's not required in a trust. Distributions. Distributions do take longer with a will than a trust. That's for sure. Typically, however, if we planned ahead of time, we can make a will work just as good as a trust. And I always am a little bit dubious when the children or the heirs, whoever, are super interested in how quickly they can get their hands on their loved one's assets. You know, I purposely at that point ignore them and slow walk it just because I can, just because it just makes me sick to my stomach, to be honest with you. So maybe that's not very professional, but that's what I do. So distributions, you know, that's is a factor. Cost of administration upon death is going to be more for a will, because you've got to have the attorney probate the estate and help through the administration process. The cost of administration of a trust is much less when the person passes away, but getting it all set up and prepared is probably 3 times more expensive on the front end. And I think I maybe told this story. There was a lady at Granny White Church that had me help her, and she had to have a trust and wanted to go that route. And sometimes when folks are older and later in their years and they really don't have that many assets anymore, one investment account, one piece of real estate, it's much easier to manage a trust and be sure everything is funded. So when that person dies, every asset is in the trust, because that's the whole point of a trust. If you don't have everything in the trust when you die, you got to do a probate anyway. So you didn't help yourself much. And a month after she died, we found out that she had another account that had $1 million in it that she was embarrassed to tell me about, that she had that much money. And she was old school. She was in her 90s or something like that. So we spent forever getting her assets titled into the trust, her knowing full well that she had another asset that I was going to have to go through probate because she just couldn't bring herself to tell me that she had another $1 million sitting there that she had inherited maybe from her parents or something like that. Well, folks, that's where, you know, there's only so much we can do to help avoid the probate process. You know, you've got to have all the facts, you know. And David, I think at the end of the day, the end of our discussion was the reason why more times than not we go the will route rather than the trust route is because I never really know, or the person is not willing to do what it takes to get everything they own titled in a trust. And if everything is not in the trust or going to be paid outside of probate through like a POD or joint account, then you're probably not doing yourself a lot of favors by doing the trust route, because I can tell you during your life, if you go the trust route and everything you own, we're going to title in a trust, that means your car, that means your jet ski, your mobile home, camper that you're pulling, that's everything that has some title. Because if it's not in the trust, then we're going to have to go through probate through the pour-over will to get it into the trust. And folks typically, after I explain that, are like, you know what? I can think of 20 things off the top of my head right now, and I don't want to have to retitle every vehicle I've got. I don't want every single thing. And when you go buy a car and you want to put it in the name of your trust, they're going to want to see your trust document. They're not going to title it in your trust just because you told them that. They're going to want to see, so you're going to have to pull out your 3-ring binder and bring it to the finance guy in the back office at the car dealership. And most people don't want to do that. So that's why I say typically it works better with folks that are later in their life and their lives are much simpler. One car or no car, one bank account, one investment account. They've already sold their house and they're living in assisted living, or they've got a house, but that's 4 things that I can put in the trust, and then it works. That being said, we can do it the other way, but that's the reason why I just, from a pragmatic standpoint, seems like it's better when we do the will route. But there are lots of benefits to trust. The next difference is maintenance of your document during your life. With a will, you do your will, you put it aside, you just change your will when something changes. I want to make my distribution different, so we'll come back to Kevin and do a new will or a codicil to the will. Or the person that was my secondary executor predeceased me, or I had a falling out with them, so I need to change that. But other than that, once you do a will, you kind of forget about it. With a trust, there's more maintenance because every single asset that you acquire in your life, you have to remember to put it in the trust in order to have it work most effectively. The next thing, helpful in emergency situations. Wills aren't really helpful in terms of assets. In the absence of a power of attorney, your loved ones can't access your accounts. But if you have the right kind of powers of attorney, they can. But with the trust, if you have a successor trustee that maybe is your oldest child and you become incompetent, there's a provision in the trust that says, upon my incompetency, this is the successor trustee. So then that person could go to the bank and take care of banking for you and things like that. So there are some benefits during that to that. I think maybe I gave this example. I can't remember if I did or not. I had it wasn't a member here, but another member of the Brotherhood. I can't believe widow or widower spouse, longtime spouse had passed away. This person then had a large, very expensive family farm that they lived on. And this person was very trusting, and the daughters of the this person were becoming worried that developers or people that were in the area might make some type of play on this family farm and go sit on the back porch and drink sweet tea with this person and gain their favor without the children even knowing. And next thing you know, you've got a farm that's worth $3 million. It's under contract to some developer for $800,000 because he brings me sweet tea every Friday. And we sit in the rocking chair at 2 o'clock every Friday. And he's done that for years. That happens. It's really a shame, but that happens. And so this family, the children, and the older person decided they didn't want that to happen. And so in that instance, that farm went into a living trust, and the older person is the trustee with the children. So now that farm can't be transferred, can't go under contract. It can go under contract, but it can't be transferred because any title company is going to want to know, okay, well, show me the trust document. Who's the trustee? So if that person goes to contract for $800,000 and the title company says, I need the trust document is going to show it's that person plus a boy and a girl, son and daughter, that have to sign too. And then that's the first they know of what's happening. And then the whole thing blows up, which is what you want. So that is a excellent planning tool in those kind of situations. Because at that point, you know, a lot of times, and I think some of us can relate to this, you know, there's only so much you want your children necessarily to know about your personal affairs. I mean, I hope it's the kind of situation where you have a child or two that you feel you can be transparent with about your financial situation, because I do think that's better than keeping everything confidential. But you're going to have to be the one that drives that discussion, because the children aren't going to want to do that, because it makes them look like they're interested in your estate and how soon they're going to get it, rightfully so. But the more transparent you can be with your children about where things are and what you have, et cetera, I think the better. Next difference, income tax, it's neutral. There's no benefit either way to a will versus trust as far as income taxes go, because a trust, a living trust, which is what we're talking about predominantly here, the taxpayer ID number is the person that is the owner of the trust assets, the grantor or the trustor, also the trustee generally. It's their social security number. So for income tax purposes, it's the same taxpayer ID number. Same thing with the, will. So there's no income tax effect. We talked about the cost benefit. We talked about privacy. Flexibility. They both can be flexible and be amended, so I think they're about the same there. Leaving assets to children, and you want those assets in to your children. Maybe you're a little worried. You have a sizable estate potentially, or what you view as a sizable estate, and when you pass away, you don't think your children are ready yet to handle that much money being given to them. So you want to set up parameters around which, if I pass away, then my assets go to my 3 children, but I want them to be in a trust account, and the trustee can use that money to pay for their education and their health care and things and their daily living expenses, but the trustee makes the decision as to what's dispersed and when, not the children, until the children reach a certain age. And then when they reach a certain age, their trust, either their silo of the trust, if you will, terminates, and that asset gets dispersed to the child outright, or it's a staggered disbursement. 10% of their silo at 25, a third when they're 30, and the balance when they turn 35, because if they haven't figured out how to take care of their money by 35, they're probably not going to, kind of thing. What we're talking about there can be set up in a will or a living trust. If you set that up in a will, then the trust language and all those parameters are written inside this document, but they spring into existence upon your death and the will being admitted to probate. That's called a testamentary trust. The trust is opened up and funded at the death of the person that wrote the will, and their assets at that point flow into those trusts for your children. Everybody that has minor children, if there's no other reason at all, I would say any folks that are 30, 35 and younger that have children, a will is always going to be the best route for them to go. And in the will, we name a trustee who's going to take care of the money when mom and dad are gone. We set the parameters as to when the kids, what money is used for what, when they get the money, etc. And in the will, you're allowed to appoint the guardian for your minor children. And because it goes through the probate process. And the court supervises and is an overseer. And unless there's some strong objection and some proof brought into court, if you say, when my wife and I are both gone, my brother and his wife are the guardians of my kids, they're going to be the guardians of your kid, and you're driving that issue, which is what you want. In a trust, that doesn't happen in a trust. So the guardianship issue has to be dealt with in a different manner. So for folks with minor children, it's always better because of the guardianship, the testamentary trust, and just the fact that you're just buying cars, selling cars, this account. They have 13 accounts, a little account here, a little account there, and it's like herding cats. There's just no way that's going to all get into a trust. The more simple our lives get, the older we get, it's much easier then to quantify and have the trust work itself out. There's no estate tax benefits to either one either. No estate tax.
Also, a good idea to talk to the people that you want to give your kids to, make sure they want them.
You think? Yes, I think that may go without saying. If you're appointing somebody as a guardian, you need to clear that with them ahead of time. Back to inheritance taxes, I think we talked about that a couple weeks ago. There's no difference as to the taxability from an inheritance tax standpoint, whether you leave the assets to your children through a will or through a trust. It's the exact same thing, whether there's what you call the taxable estate and the probate estate, and inheritance taxes is not based on your probate estate, it's based on your inheritance tax estate, and the IRS has different rules for that. If you have a trust, we also do a will. It's called a pour-over will, and I think I did mention this, and you may say, well, I thought we're not doing a will if we do a trust. Well, you got to do a will when you have a trust to catch those things that the lawyer didn't know about and didn't help you get titled into your trust, because if you're going the trust route and that's the vehicle that determines where everything goes, everything's got to get into that trust. And if you die with the account like that lady did, that trust in her name, we had to do probate the pour-over will. And it's just a simple will that says, when I die, everything I have goes into my trust. That's the entire will. But I probated that, appointed an executor, took control of that asset, titled it in the name of the trust, and here the trust then dictated how everything got dispersed out. So that is how that works. And I've reached the point in my career now where I'm starting now to administer estates that I did the wills and trusts for. Been practicing long enough now where that's starting to happen more and more, obviously, and I would say about half the time when somebody dies with the trust that we don't have to go to probate. About half the time, everything passed through the trust, but about half the time we got to go to court. I got to probate the pour-over will to get a couple assets that they didn't title correctly into the trust. So that's the main two differences. hope that didn't confuse it any more than, I hope it didn't confuse you to the extent that you don't even know now what I'm talking about. But I think to summarize, when we get older and our life gets simpler, trust can be a really good vehicle, because you can get everything into trust and avoid probate and the plan work, and you can name a child as a co-trustee because you know you need protection. And that scenario I was giving you, that's happened more than one time in my career. You know, I had one where we went the trust route for the older lady. We titled her house in the trust, and a vinyl window salesman came to her and convinced her that she needed $50,000 of replacement windows in her house. And she signed a contract, and they tried to put a lien on the property based on what she had signed in front of that person there at her dining room table. But we were able to unravel it because it was in a trust, and her son was the co-trustee of the trust. So they couldn't secure it because we had gone that route. So the older we get, I think it's something really to consider, and something that can be valuable and helpful. Younger in your life, it's so cumbersome. I think typically wills are what you need. And the other thing too is, most of the time, statistically speaking, the folks that are on the younger side of things, we don't probate many wills of younger people, thankfully. You know, I've had a few that fairly young, younger than they should be, but generally speaking, that's not so. Anyway, I'll hang around if y'all got any questions, and then 2 weeks from now, we'll jump back and we'll kind of segue into powers of attorney and how they kind of fit into everything in the living will / advanced care directive. So if you don't mind, let's say a prayer as we close. Father, we're thankful for this opportunity to be together with like-minded brothers and sisters, to be edified through a message and singing and praying together. We're thankful for the time that we can think about how to be good stewards of what you've blessed us with. Be with us tonight as we go home, and if the weather, it's raining or snowing, keep us safe. Continue to bless us. Bless the health of this congregation, not only from a spiritual standpoint, but from a physical standpoint, that we will all be healthy and get back to some normalcy sooner than later. Father, we love you, and we thank you for your Son and what he did for us, and it's in his name we pray. Amen.